And so the second issue in contracts, once we have determined that there is an offer and that offer is alive and well, it hasn't been terminated, is whether that offer is accepted, because the second step in contract formation in sequential assent, at least in sequential offer and acceptance, is that acceptance by the offeree. Acceptance is the manifestation in a manner invited or required by the offer of assent by the offeree, to be bound by the terms of the offer. So again, the offeror will have all the terms in the offer. All the offeree can do is accept those terms, reject those terms, or propose substitute terms, which function as a rejection. So don't be confused. The offeree does not propose the consideration, as we'll come to. Both the promise and the consideration, the entire exchange, is contained in the offer made by the offeror, and then the question is whether the offeree accepts or not. Usually the way it works is something called sequential assent. The manifestation of mutual assent to an exchange ordinarily takes the form of an offer or proposal by one party, followed by an acceptance by the other party or parties. And so that's what we'll discuss, the usual course of business in contracting. How can that offer be accepted? Any reasonable manner of acceptance will do, unless something was precluded by the offer, such as, I don't want a promise, you have to fully perform, or except by coming to my office at 3 o'clock on Tuesday with the signed document, right? That would preclude potentially other forms of acceptance. But if the offer doesn't say that, if I say to you, I'd like to sell you my car on Tuesday for $10,000, and you send me a text message that says, sounds good, that's probably an acceptance. If you send me an email, if you tell me verbally, if you show up with $10,000, those are all probably valid acceptances because they're not precluded by the offer. And going back to the idea of showing up with $10,000 and asking for the car, that would be considered acceptance by conduct. And acceptance for conduct can be made where that conduct is intentional, where the party did not accidentally do an action, but intentionally conducted an action, right? Intentionally made an act or intentionally failed to act, and where that would reasonably be inferred as assent. So the party is intentionally making an action or intentionally refraining from an action. And again, going with that third-party concept, how will the counterparty see that? A reasonable counterparty will see that as assent. And that would include silence. So not acting can, in some unusual cases, constitute an acceptance. And the restatement section 69 talks about that in some more detail, but to summarize it, restatement section 9 says that an offeree can accept by silence when they take the benefit of an opportunity, implying that they wanted the contract, or when the offeree knows that that silence or inaction will be understood as assent. And so you might have an offer that says, if you do not say anything within 10 days, I will proceed as we have discussed. In that case, not saying anything within 10 days would be reasonably understood as manifesting assent. We talked about unilateral contracts. The more ordinary one is bilateral contracts, where both parties will make a performance. How do you accept a bilateral contract? Well, you can accept by promising or by beginning performance. So beginning performance of a bilateral contract shows an intent to be bound by its terms, and so beginning performance of a bilateral contract is an acceptance of that contract. Now, as a reminder, what is beginning performance of a unilateral contract? Unilateral performance? Well, that can't be acceptance, because a contract for a unilateral contract, a contract that can only be accepted by performance, can only be accepted by complete performance. So beginning performance cannot be acceptance, but it does create a quasi-option contract to complete that performance for a reasonable time. See section 45. Offers for unilateral contracts can only be accepted by complete performance. That is Rule 53. So we understand then what happens when you begin performance under a bilateral contract, an offer for a bilateral contract, or an offer for a unilateral contract. So what terms do you accept? We looked at the case of Meyer versus Uber Technologies. This had to do with click-through licensing on an app. This app had a provision that I'm sure many of you have signed, that many of you who have used Uber have probably agreed to a term that says you will be bound by arbitration. The question is, are you actually bound by the term in these type of agreements? And they're becoming much more prevalent today. To cut to the chase, the court has a rule for us, and the rule is that the offeree will be bound by the terms if a reasonably prudent user would be on inquiry notice of the terms. And so again, we have that reasonableness concept, that eye in the sky. What would a reasonably prudent user think about this? Now that will turn on some factors. Those factors include the clarity of the contract, the conspicuousness of the terms, the length of the contract, the nature of the parties, and many other terms. But not every term in a contract will automatically be deemed accepted. And by the way, in terms of this, with privacy policies under the GDPR, it has to be very, very clear or it's not enforceable as well. That brings us to the Mailbox Rule, and so the Mailbox Rule takes effect when parties are not negotiating face-to-face, but negotiating, and not over the phone, but through a series of correspondence. And so this is kind of going back to letters in the mail, but it's also applicable to email. And actually, I'd like to make the Mailbox Rule quite simple for you. The simple version is that acceptances are effective upon dispatch. So these puppies are effective as acceptances because they are in the mailbox with the flag up, at least the one with the flag up is, whereas everything else is effective when actually received. And so offers, rejections, revocations, those need to be received, but acceptances, those are effective upon mailing. This is called the Mailbox Rule, and it dates back to a time when mail was the more prominent way of engaging this sort of correspondence agreement. And it's called that because it was presumed that when you put your mail in the mailbox, you lost control of it, and at that point it became an acceptance. Nowadays we will apply this standard to fax and email. But again, what is that rule? When are actions effective? Only acceptances are effective when sent. Offers are effective when they are received. Rejections are effective when they are received. Revocations are effective when received. Only acceptances are effective when they are sent. What do we mean by sent? Well, sent in the case of email means that the email was addressed properly, and you got the right, you didn't send it to the wrong address, and it was addressed to the recipient's information processing system. And it's a more technical definition, but the idea is you got their email address right. It's in a form capable of being processed by that system. And so, if it's an encrypted file, that could be a problem, but your general sort of letter or attachment is fine. And it then enters that system. And that's sort of interesting because it has to actually enter the other person's system. It has to get into their system. We get some questions about spam folders there as well. Email is received when it enters an information processing system that the recipient has designated in a form capable of being processed by that system. And so we see the Mailbox Rule applied to the modern electronic commerce through the UETA, Uniform Electronic Transactions Act, UETA. And so that gets us through acceptance. And so we now have the question of if there was an offer and acceptance, if there was mutual assent, was there consideration?